This appeal raises serious legal questions that any court must take seriously. The allegation that a repealed law was applied in sentencing, the question of allocutus being denied, the preliminary objection that was never resolved before verdict, these are not political talking points. These are procedural issues. Now, whether the appeal succeeds in court or whether this matter is resolved through political channels before then, nobody can say with certainty today. What I can tell you is that both possibilities are very much alive right now. And the outcome of either one will have consequences far beyond Nnamdi Kanu himself.
Before you scroll past this video, before you decide this is just another update, I need you to stop right where you are. Put down whatever you are holding and listen carefully. Because what is unfolding right now inside the Nigerian judicial system concerning Nnamdi Kanu is bigger than a court case. It is bigger than one man. It is a defining moment for the entire Igbo nation, and the decisions being made inside those courtrooms and behind those closed political doors will shape the Southeast for the next 20 years. The appeal court has made its move. The politicians are making their own moves, and whether Nnamdi Kanu walks free or remains in that Sokoto prison depends on which move lands first. Stay with me. Everything changes now. Welcome back to this channel. If you watched my last video, you already have the foundation. But for those joining us today, let me bring you up to speed quickly. On November 20, 2025, Justice James Omotosho of the Federal High Court in Abuja delivered a verdict that shook the entire Igbo world. Nnamdi Kanu, the director of Radio Biafra and leader of IPOB, was convicted on 7 counts of terrorism-related offenses. 7 counts. And the sentence was not 5 years, not 10 years. It was life imprisonment. Life. That means they looked Nnamdi Kanu in the eye and told him he would die inside a Nigerian prison. And as if that was not enough, they moved him to a correctional facility in Sokoto State, over 700 kilometers from Abuja, far from his lawyers, far from his family, far from the court where his appeal will be heard. That distance is not an accident. Nothing about how this government handles Nnamdi Kanu is ever an accident. But here is where the story pivots. On February 4, 2026, Kanu did something that stunned even his critics. Without waiting for a team of senior advocates to save him, he personally filed what his legal team described as the mother of all appeals. 22 grounds of appeal, 22 direct, surgical legal arguments aimed at dismantling that conviction brick by brick. And now the Court of Appeal in Abuja is being forced to engage. Today, I am going to walk you through the 5 most critical steps this court has taken, and what each step means for Kanu, for justice, and for the Igbo people. We are counting down from 5 to 1, because number 1 will change how you see this entire situation. Step 5. Step number 5. The appeal court struck out his rights violation suit and called the whole thing academic. Before Kanu was even convicted, while he was still being held in DSS custody, he filed a suit challenging the conditions of his detention. He said they were denying him adequate medical care. He said they were violating his freedom of religion. He said he was being treated not as a remand prisoner awaiting trial, but as a man already condemned. These were serious, documented allegations about his fundamental human rights. That case eventually went before the appeal court. A 3-member panel led by Justice Bolaokoromo Yugo heard the matter, and what was their response? They struck the suit out. Their reason? They said the matter had become academic because Kanu had since been convicted and transferred to Sokoto. Since he was no longer in DSS custody, his complaints about DSS conditions were no longer relevant. Now let that sink in. They did not say his rights were not violated. They did not investigate the substance of his claims. They simply said the timing had passed and the complaint was now old news. This is the system Nnamdi Kanu is navigating. A system that can delay your case long enough that your suffering expires on paper, even when it never expired in real life. Step 4. Step number 4. The court rejected his prison transfer request and abandoned him in Sokoto. After the conviction and transfer to Sokoto, Kanu filed an application through his lawyers asking to be moved to a facility closer to Abuja so he could actively prepare and participate in his appeal. This is not an unusual request. A convicted person has a constitutional right to appeal, and that right is meaningless if you cannot communicate with your legal team or appear before the court that is deciding your fate. Justice Omotosho struck out that application and declared it incompetent, but what made the situation even more disturbing was what happened with legal representation. The lawyer assigned to Kanu through the Legal Aid Council, the government's own legal aid body, withdrew from the case. He cited irreconcilable differences and walked away. Nobody was left to sign the necessary court documents. Nobody showed up to argue on Kanu's behalf in that hearing. Think carefully about what this reveals. You sentence a man to life imprisonment. You move him 700 kilometers away. You deny his request to come closer to fight his case. And when he cannot even secure independent legal representation because the government controls access, the court-assigned lawyer quietly exits the room. This is not procedural oversight. This is a pattern. Step 3. Step number 3. The Court of Appeal is now officially seized of the main conviction appeal and cannot ignore it. Despite every obstacle, despite the isolation in Sokoto, despite the withdrawal of legal aid, the appeal was filed. On February 4, 2026, the notice of appeal was formally lodged at the Court of Appeal in Abuja. The case now carries the reference CA-ABJ-CR 2026. The Federal Republic of Nigeria is the listed respondent. The matter is officially before the court. This is a turning point that cannot be understated. Once the appeal is properly filed and accepted, the game changes. The federal government can no longer behave as though this matter is concluded. They must now respond. They must file their own processes. They must appear before the court and justify every aspect of that trial and conviction. And Kanu has announced that he intends to be physically present in court and may conduct portions of the appeal himself. Some of the grounds in that appeal are extraordinarily powerful. He is arguing that he was convicted under a law that had already been repealed before the judgment was even delivered. The Terrorism Prevention Amendment Act of 2013 was replaced and repealed by the Terrorism Prevention and Prohibition Act of 2022. If a judge uses a law that no longer exists to sentence a living human being to life imprisonment, that judgment is not standing on solid ground. It is standing on nothing. Step 2. Step number 2. The 22 grounds of appeal tear open the entire trial and expose what really happened in that courtroom. I want to go deeper here because this is the heart of the appeal. 22 grounds is not a number you produce by guessing. Each ground represents a specific legal failure that Kanu is saying occurred during his trial, and several of them are explosive. He is arguing that in September 2017, Nigerian soldiers invaded his home in Afararakwu during Operation Python Dance II. People died. His compound was destroyed. He had to flee the country for his life. That interruption, he contends, permanently broke the continuity of the original trial and was never properly addressed by the court. The trial continued as if a military invasion of a defendant's home was a normal occurrence. He is arguing that when the judge delivered his verdict, a preliminary objection filed by the defense, one that directly challenged the competence and validity of the entire proceedings, was still sitting on the judge's table undecided. A judge cannot deliver a guilty verdict while a fundamental challenge to the trial's validity remains unresolved. That is not procedure. That is a contradiction. He is arguing that he was sentenced to life imprisonment without being granted allocutus, the basic, fundamental right of every convicted person to address the court before sentencing and appeal for leniency. That right was not given to him. And he is raising double jeopardy, that the facts used in this trial were facts that a previous court of appeal had already nullified and set aside. If those facts were dead, you cannot resurrect them to convict a man. If even 3 or 4 of these grounds are sustained, the conviction cannot survive. Step 1. Step number 1, and this is the one that truly changes everything. A political deal for Kanu's freedom may already be in motion, and it could happen before the appeal is ever decided. Now we enter the territory that nobody on camera wants to speak plainly about, because in Nigeria, the most powerful court is not the Court of Appeal. It is not even the Supreme Court. The most powerful court in Nigeria is the negotiating table inside Aso Rock. Governor Alex Otti of Abia State, after a private meeting with President Bola Tinubu, stood before cameras and made a statement that should have broken the internet. He said, and I am choosing my words carefully to represent his meaning accurately, that Tinubu is favorably disposed to the question of Kanu's release, and that Nnamdi Kanu would in no distant future regain his freedom. Ohanes Ndigbo has also publicly and formally called for his unconditional release. Southeast governors have been making quiet trips to Abuja, and with the 2027 general elections approaching rapidly, every political strategist in Nigeria knows that a restive, angry Southeast is a liability no president can afford. Here is the uncomfortable, controversial truth that this channel will say clearly. The appeal may never reach a final judgment in court. What is far more likely, based on everything happening behind the scenes, is that Nnamdi Kanu's release will come through political negotiation, not judicial vindication. The question Igbo people must ask is not whether he will be freed. The question is what the terms of that freedom will look like, who is negotiating on behalf of the Igbo people, and whether Kanu himself will accept conditions that he once said he would never accept. Will he be asked to formally end the sit-at-home order? Will IPOB be expected to stand down its enforcement mechanisms? Will Kanu sign a document that his supporters will later call a betrayal and his enemies will call a surrender? These are the real questions, and the answers are being written right now in rooms where no camera is allowed. Altro. Nnamdi Kanu is fighting the most important battle of his life on two simultaneous fronts. Inside the courtroom through 22 carefully constructed legal arguments, and outside the courtroom through the political calculations of governors, elders, and a president who needs the Southeast to be calm before 2027. Both fronts are real, both fronts are moving, but only one of them will be the front that actually determines whether he walks out of that Sokoto prison as a free man or as a man who purchased his freedom at a price that history will spend years debating. Share this video with every Igbo person you know. Comment below and tell me what you think. Will Kanu's release come through the courts or through a political deal? And if it comes through a deal, will it be a victory or a transaction? Like, subscribe, and stay close to this channel, because this story is not over, it is just entering its most dangerous chapter.